Hello. From the last few days, there are various Supreme Court judgments, and while writing polity answers, governance answers, even in ethics and essay, we need to quote certain judgments of the Supreme Court. In the recent past, there are various landmark judgments and decisions given by the Supreme Court on myriad of issues. Now, I'll discuss some important cases and judgments given in the recent past. As you all know, Article 21 of the Indian Constitution deals with right to life or personal liberty. Article 21 from Maneka Gandhi versus Union of India case onwards have become a new umbrella where many rights were being guaranteed under personal liberty. From Maneka Gandhi versus Union of India onwards, many rights were guaranteed under personal liberty. As you all know, in Maneka Gandhi case, Maneka Gandhi passport was impounded by the then government, that is the Janata government, and she went to the Supreme Court saying that right to go abroad is her fundamental right. If somebody denies, some authority denies her fundamental right, there should be some reason, and the reason should be just and fair. And the court told right to go abroad is a fundamental right under personal liberty, and if her fundamental right is taken away, there should be some reason, and the reason should be just and fair. It should not be arbitrary, artificial or evasive. It should not be arbitrary, artificial or evasive. And the court also said that law does not mean enacted piece of law. Law does not mean enacted piece of law. Law means a reasonable law. Law means a reasonable law. And court also told natural justice is a great humanizing principle. In Maneka Gandhi case, court also told natural justice is a great humanizing principle. Till Maneka Gandhi case, we have not followed due process of law. Till Maneka Gandhi case, we have not followed due process of law. Due process of law is an American doctrine basically. Due process of law means following principles of natural justice, fairness, equity while taking decisions and pronouncing judgments. But from Maneka Gandhi case onwards, we had due process of law concept. So in 2017, in right to privacy judgment, Puttaswamy versus Union of India, the most important case in the recent past was Puttaswamy versus Union of India. Nine judges unanimously told right to privacy is a fundamental right of citizens. Right to privacy is a fundamental right of citizens. Puttaswamy versus Union of India. If we go little past, in Karak Singh case, the Supreme Court told right to privacy is not a fundamental right. But in the recent past, in 2017, in Puttaswamy versus Union of India, the Supreme Court told right to privacy is a fundamental right. 9 judges bench of the Supreme Court told this judgment. They gave this judgment. And few days back, we got plenty of judgments. Before going to that, there is one more landmark judgment which was given by the Supreme Court last month, Navtej Johar judgment. Navtej Johar judgment. In that judgment, it was said that the Supreme Court gave a ruling that Section 377 of IPC. Section 377 IPC with respect to LGBT rights is unconstitutional. Section 377 of IPC with respect to LGBT rights is unconstitutional. Now you may get a doubt. What is this section 377? Section 377 punishes for unnatural offences. Unnatural offence is an offence which is not according to the nature. It is against the nature. For example, a relationship between a man and a man, woman and a woman, a human being and other living creature is considered as unnatural. For example, in the society we are observing gay relations, lesbian relations, etc., which are not in accordance with the nature. These things are called unnatural, and section 377 punishes for unnatural offences. Remember a point, section 377 is not completely struck down. Section 377 of IPC is not completely struck down. Only to the extent of LGBT rights, section 377 was declared as unconstitutional. Even today, section 377 have a validity. The reason is, if a human being had a relationship with an other living creature, then it is called unnatural. 1 month back, we have a news, 1.5 months back, 8 men raped a goat. 8 men raped a goat. So this is considered as unnatural. This is considered as unnatural. So till these types of crimes exist, section 377 is relevant. So only with respect to lesbian relationship, gay relationship, section 377 is declared as unconstitutional. In Latha Johar case, even today section 377 have a validity, it have its existence. And this section 377 of IPC was in controversy from last 9 years. In 2009, in Naj Foundation case, in 2009, in Naj Foundation case, the Delhi High Court told section 377 is unconstitutional with respect to LGBT rights. But in Suresh Kumar Kaushal case in 2013, the Supreme Court told Delhi High Court judgment is not right. Section 377 is right. Section 377 is constitutional even with respect to LGBTs. That means section 377 you can punish LGBT relationships. And now a curative petition was filed. A curative petition was filed. In that curative petition, in Latha Johar, this is Latha Johar judgment, section 377 to the extent of LGBTs, section 377 of IPC to the extent of LGBTs was declared as unconstitutional. Coming to important judgments given last week. Live streaming of Supreme Court cases. Live streaming of Supreme Court cases. Supreme Court allowed live streaming of court proceedings, and you can online see the court proceedings. It's very good gesture for bringing transparency and accountability in judicial proceedings. Live streaming will also mean democratization of the court. Democratization of the court proceedings, as the footage will be available to all. As the footage will be available to all. Adequate precautions should be taken for ensuring to maintain secrecy and privacy of litigants with respect to cases like sexual assaults, juvenile offenders, national security issues, etc. So it is not that each and every case will be live streamed. Some cases like sexual assaults, juvenile issues or national security issues, they were exempted. They were exempted. Initially, they won't do all proceedings as live proceedings. Initially, it will be launched on pilot project. Only cases of constitutional and national importance. Only the cases of constitutional and national importance. And when they have come only for final hearing before the constitutional bench. When they have come for only for final hearing before the constitutional bench. This is the important judgment. live streaming of court proceedings. Next case, in the recent past, MPs and MLAs, that means our legislators in the central level and state level, MPs and MLAs can practice law. They can, along doing the MP post, MLA post, they can also practice law. Though MP and MLA is a public servant, his nature of job is very unique. He is not barred from practicing law. The provisions of Advocates Act 1961, the provisions of Advocates of Act 1961 and rules framed under Advocates Act do not place any restriction on MP or MLA to practice law. The closest rule, Rule 49 of Bar Council of India. Rule 49 of Bar Council of India says, lawyers who are in practice should not do government job. Though MP MLA is a public servant, his work is like unique nature and he is not like a full-time salaried government employee. So MP MLA can take a legal practice. They can continue their practice. This was a recent judgment. Next judgment, very important. Common Cause versus Union of India. The case citation is Common Cause versus Union of India 2018. This judgment was delivered by the Supreme Court in March 2018. In India, basically, euthanasia is not allowed. Mercy killing is not allowed in India. The reason is, in the Indian circumstances, we can misuse the mercy killing provisions. For that reason, central government even argued not to allow passive euthanasia in India. Coming back, there was a case few years back called Gnan Kaur versus State of Punjab. GIANKAUR. Gnan Kaur versus State of Punjab. In that case, it was said that right to die is not a right in India. In fact, right to die did not come under personal liberty in Article 21. Right to die is not a right in India. Right to die is not a personal liberty under Article 21 in Gnan Kaur versus State of Punjab. See, in Common Cause versus Union of India, in the recent judgment, the Supreme Court allowed passive euthanasia. Passive euthanasia. The Supreme Court said, right to die with dignity is a fundamental right. Right to die with dignity is a fundamental right. Supreme Court allows passive euthanasia and living will. Supreme Court allowed passive euthanasia and living will. The right to life and liberty as envisaged under Article 21 is meaningless unless it encompasses individual dignity. Unless it encompasses individual dignity. With the passage of time, the Supreme Court expanded the spectrum of Article 21 to include within it various rights, and quality of life is also equally important. Not just life, quality of life. Coming to the point, there are 2-3 issues here. First case, Gnan Kaur. Right to die is not a fundamental right. Right to die do not come under personal liberty. Whereas, in Aruna Ramachandra Shanbag versus Union of India, in Aruna Ramachandra Shanbag versus Union of India, the Supreme Court told, in exceptional cases, we can allow right to die. Passive euthanasia. Under observation of the government and the court. Passive euthanasia is allowed. In the exceptional cases, not in all cases, only in the rare cases. Whereas, in the recent judgment in Common Cause versus Union of India, the court allowed passive euthanasia, that is right to die with dignity, and also Common Cause versus Union of India 2018, the Supreme Court also held that the right to live with dignity also includes smoothing of the process of death. When a person is terminally ill, there is no hope for living, there is no hope for life, then he can be allowed to go with euthanasia. Advance directive and the right to self-determination is allowed. Advance directive and the right to self-determination is allowed. What is this advance directive and the right to self-determination? A sick patient, before he becomes mentally insane or incapable of giving his own consent, he can write a directive. In case if something happens to him, he can empower his family, or he can tell that passive euthanasia can be allowed to him. That passive euthanasia can be given to him. So this is called living will. A man can issue an advance directive for living will by telling that I can be treated like this. Passive euthanasia can be given to me. So in Common Cause versus Union of India, passive euthanasia was allowed, and right to live with dignity, and it also allows living wills of the persons. Next important case, as you all know, very historic case, Sabarimala temple entry. Sabarimala temple entry. The Supreme Court declared that there is no bar on the entry of women in the Sabarimala temples. There is no bar on the entry of women in the Sabarimala temple. The convention is, the custom is, women between 10 to 50 years, they are not allowed to enter into Sabarimala temple. Public interest litigation was filed by Indian Young Lawyers Association 12 years back on this issue. Public interest litigation was filed by Indian Young Lawyers Association 12 years ago on this issue. The Supreme Court has opined that the dignity of an individual is an unwavering fundamental right. Disrespecting women, disallowing women, treating women as second-grade citizens is not allowed. Disrespecting women, disallowing women, treating women as second-grade citizens is not allowed. Justice Chandrachud said, to treat women as children of a lesser god. Justice Chandrachud said, to treat women as children of a lesser god is to blink at the constitution itself. Is to blink at the constitution itself. Remember, Justice Chandrachud said, to treat women as a children of lesser god is a blink on the constitution itself. The majority, 4:1, the Sabarimala judgment is given by 4:1 majority. Only one judge is dissenting judge. The majority has stated that the right to freedom of religion also includes the right to practice religion without any fictitious or vague constraints. Without any constraints, without any fictitious or vague constraints, anybody can enter into the temple. So, positively establishing women's rights to enter into the temple. Positively establishing. The one dissenting judge is Justice Indu Malhotra. The one dissenting judge is Justice Indu Malhotra. She stated that rationality has no place in matters of religion. Rationality has no place in matters of religion. She also told the judgment in Sabarimala case has a far-reaching consequences on all important practices. Unless it is a grave social evil like sati, we should not interfere in religious practices. She said it is the matter of faith and religion. Court should not interfere in the Sabarimala issue. This is in simple crux. But 4 judges told religion should conform with fundamental human rights, basic human rights. Women's rights cannot be denied in any religious denomination. And the court also said Sabarimala is not a separate religious denomination. The court also said Sabarimala is not a separate religious denomination. Next important case, Joseph Shine versus Union of India. Joseph Shine, nothing but adultery case. It is adultery case. A married woman, if she has a relationship with a man who is not her husband, it is called adultery. Or a stranger having relationship with a woman who is not his wife is called adultery. In adultery, the husband of a woman, if a woman commits adultery, can file a case on a third person, on the stranger. But the woman cannot file a case on the husband if husband commits adultery, or the woman cannot file a case on the other woman with whom the husband is committing adultery. So, adultery law, section 497 of IPC gives powers to the husband to own a wife husband is not the master of wife. Wife is not the property of the husband. This was the argument of the judgment. Two consenting individuals, whether married or unmarried, if they are in voluntary consensual relationship, why should it be a crime? This was the argument of the court. But in the Indian culture, we think in a different way. We think in a different way. So, section 497 of IPC now was considered as unconstitutional. In the original constitution, in the original Indian Penal Code, in 1860, 158 years back, adultery was declared as a crime in India through IPC, Indian Penal Code, and to the maximum of 5 years punishment can be given to the stranger if the adultery is proved. To the maximum of 5 years punishment can be given to the stranger if the adultery is proved. This is a path-breaking judgment in India today. A 5 judges bench ruled that section 497 of IPC violates women's rights of equality and treats them like the property of the husband. It's a time to say that a husband is not a master of the wife, and a husband could prosecute under section 497 any third person, even though the relationship between the wife and third person is voluntary. This is highly discriminatory according to the court. This is highly discriminatory, and this 497 of IPC is against Article 14, Article 15 Clause 1 and Article 21. Article 14 right to equality, Article 15 Clause 1 prohibition of discrimination, Article 21 personal liberty of women. So, the court declared this as unconstitutional. The court declared section 497 giving punishment to adultery is unconstitutional. Now adultery is not an offence. Now adultery is no more an offence. Though it's a ground for divorce, it is no more an offence. If a wife commits adultery, husband can apply for divorce, but husband cannot ask for punishment of the stranger. So adultery is no more an offence now. Section 497 of IPC now declared as unconstitutional. Again, adultery means a married woman having a relationship with a man who is not her husband, or a stranger having relationship with a married woman who is not his wife. Next important judgment, Aadhaar judgment. Next important judgment is Aadhaar judgment. A 5 judges constitutional bench of the Supreme Court, upheld the constitutional validity of Aadhaar. Court also said it is mandatory to link PAN card with Aadhaar. It is mandatory to have Aadhaar for filing IT returns. Aadhaar is also necessary for welfare schemes and subsidies, but Aadhaar is not needed for opening a bank account. Aadhaar is not needed for opening a bank account. Aadhaar is not needed to write exams like NEET. Aadhaar is not needed for school admissions. Supreme Court has struck down section 57 of Aadhaar. Private entities like telecom companies now cannot mandatorily ask the Aadhaar data and store the data. You cannot mandatorily ask Aadhaar data or store the data. Supreme Court struck down national security exception. This means investigation agencies in the name of national security without a judicial warrant cannot take Aadhaar. Investigation agencies now can require an Aadhaar only with a proper judicial warrant. And while giving the Aadhaar judgment, the Supreme Court also told a strong data protection law is a must in India. Another important judgment, though disappointing, has a far-reaching impact. Another important judgment of the Supreme Court, though disappointing, has a far-reaching impact. The judgment is relating to barring the politicians facing charge sheet on crimes from contesting the elections. Barring the politicians facing accusation of heinous crimes from contesting the elections. So, you all know Section 8 of Representation of People's Act deals with criminals entering into politics. But the people on whom criminal charges were made still are contesting elections. In fact, some of the MLAs and MPs have a list of criminal allegations and cases pending in the courts. Now the thing is, criminal charges like rape, murder, kidnapping, etc. should be, these criminal charges should be taken seriously and criminals should be barred to enter into politics. A 5 judges bench led by Chief Justice Deepak Mishra said, the court cannot play the role of parliament. The court cannot play the role of parliament. Here, the judge told, parliament should make effective law to stop criminals entering into politics. Just because there were accusations of serious nature on a politician the court cannot bar him from contesting the election. But it is up to the parliament to have an effective law to stop allowing criminals entering into the politics. National interest demands parliament to enact very good legislation, and the country awaits for such a legislation to ban criminals entering into politics. These are the important judgments given by the Supreme Court in the recent past.